Good afternoon, ladies and gentlemen, boys and girls. Welcome to Amity University, a research and innovation-driven university. Today, we are 12 universities in India with 16 global campuses and 28 schools and preschools, following the ideas and the values laid down by our founder president, Dr. Ashok K. Chauhan, sir, who believes that every Amitian is an asset to the society and the nation and also the expanding global village as we believe in what we call as Vasudhaiva Kutumbakam. Welcome to the webinar series on Transgender Persons Rules 2019, Act 2019 and Rules 2020. So we are hosting 10 webinars, all sponsored by Ministry of Social Justice and Empowerment, and welcome to the 6th webinar in the series. So up the panel today, we have eminent speakers on the days. We have with us Dr. Mitali Srivastava, we have with us Mr. Saksham Jain, we have with us Dr. Santosh Kumarji, we have with us Dr. Amit Dhal sir, and we all are supported and guided by our Additional Director and Joint Head, Professor Dr. Aditya Tomar sir. So let's begin today's webinar by invoking the goddess. But before that, I would like to tell you what is the theme of today's webinar. Today's theme is the Transgender Persons Act 2019 and the Rules 2020, vis-a-vis the right to self-identification and right to privacy, primarily because both are inseparable somehow. And there is right to life means right to life. There is nothing beyond life. So let's try to go ahead with the brainstorming and the intellectual webinar. But before that, we would like to invoke the goddess of learning. Allow me 1 minute to share the screen, to share the Saraswati Vandana.
Om Bhurbhuvah Swaha Tatsaviturvarenyam Bhargo Devasya Dhimahi Dhiyo Yo Naha Prachodayat Dhiyo Yo Naha Prachodayat. He Sharide Ma, He Sharide Ma, Ajnanita se hame tar de Ma. He Sharide Ma, He Sharide Ma, Ajnanita. Om Bhurbhuvah Swaha Tatsaviturvarenyam Bhargo Devasya Dhimahi Dhiyo Yo Naha Prachodayat Dhiyo Yo Naha Prachodayat. He Sharide Ma, He Sharide Ma, Ajnanita se hame tar de Ma. He Sharide Ma, He Sharide Ma, Ajnanita. Om Bhurbhuvah.
There is actually some problem in the video, but with the invocation of the goddess of learning, let's all embark on a journey today where we empower the transgender persons and also all of us so that we have become more aware and more sensitized towards what we call as identity, towards what we call as self-expression, towards what we call as the glorious form of individuality, that is humanity. Having said so, I will now request the torchbearer of this webinar series, none other than our very dear and respected Joint Head of the Institution and Additional Director, Professor Dr. Aditya Tomar sir, to present the opening remarks. Over to you, respected sir.
Thank you, Dr. Sumitra. So, without wasting much of your time, I just want to thank you to all the guest speakers, internal and external. And I would like to extend my heartiest welcome to Mr. Saksham Jain ji, Dr. Mitali Srivastava ji, Dr. Santosh Kumar ji, and Dr. Amit Dhar, with our dear colleague, the coordinator, Dr. Nitin Sharma, Dr. Sumitra, Dr. Supana, and the other faculty members who are day and night involved in the organization conduction of this webinar series. Basically, we, the part of MIT Law School, Noida, under a project of National Institute of Social Defense, Ministry of Social Justice and Empowerment, Government of India, are organizing a series of webinars. Through the series of webinars and some physical events, we are just trying to sensitize the students, public in general, public at large, to sensitize the issues related to the most vulnerable sections or most important sections of our society, that is disabled, transgenders, and the persons who need a special care in this society at the present times. So just to complete our social responsibility, moral responsibility vis-a-vis legal responsibility, this webinar is based on the Transgender Persons Act 2019 and vis-a-vis right to self-identification and right to privacy. So I believe that today's session would enlighten our student, faculty member of different law schools, including the 11 law schools of Amity Group in India and one law school, the one or the only law school, Amity Law School, Dubai, which is affiliated with the Bar Council of India, but outside the boundaries of India. That is Amity Law School, Dubai. So I welcome to all the participants, speakers, one and all. Thank you. Thank you very much.
Thank you so much, respected Aditya. So you always inspire us, and it's all because of your motivation that Amity Legal Aid and Literacy Committee is soaring great heights day by day. Well, everybody, at Amity Legal Aid and Literacy Committee, we now have a totally dedicated cell to cater to the needs and the challenges and to make the Transgender Persons Act 2019 aware to the entire public, to the people. And for that, the dedicated cell here is at gate number 2A, which we call as our satellite office. It's at gate number 2A of the university premises. And for that, if you have any problem, if you come across any person who requires any kind of assistance, then you can dial our number, that is 0120-439-2807. Well, everybody, I would now hand over the days to the moderator for today, Dr. Suparna Vinayak ma'am, our co-moderator and the co-host. Dr. Rajat Banerjee sir will be joining soon, and together with me is the convener of this webinar series, Dr. Nitin Sharma sir. So I will now request Dr. Suparna ma'am to invite Nitin Sharma sir and take the panel discussion ahead. Over to you, respected ma'am.
Thank you so much, ma'am. Thank you, Aditya Thomas, sir, for enlightening us how we are going with the webinar series. Indeed, it is a great pleasure to welcome everyone on this platform where the webinar series is going on. Then this is our 6th webinar, which is with reference to the Transgender Persons Act 2019 and the rules of 2020, the Transgender Persons Protection of Right Rules 2020 vis-a-vis right to self-identification and right to privacy, which Sumitra ma'am has already highlighted. Now I request to Dr. Nitin Sharma. I think sir is here. Yeah, sir is here. I request him to please start the proceedings where he can invite other speakers also. Thank you, sir.
Thank you so much, ma'am. So first of all, most welcome to the esteemed guest. And as our giant Uchai, Dr. Professor Aditya Tomar sir has already highlighted the need of this gender sensitization program. And as sir has already told us and highlighted this fact that it is out of our not only it's like legal obligation, but it is also the moral, ethical, and keeping in view the legal considerations of present scenario, and as well as the evolving jurisprudence in terms of human rights as well as the Constitution of India. We are doing this series of webinars in collaboration with the Ministry of Social Justice and Empowerment. And till now, we have conducted 6 webinars. And as far as the previous webinars are concerned, we have tried to touch each and every aspect of the issues which the transgender community is facing. And likewise, we have focused upon the non-discrimination provisions within the Transgender Act in the first webinar. Then the second webinar, we discussed about the grievance redressal mechanism. What are the health rights of the transgender people? Then we can say the inclusive education within the Transgender Persons Act. Then the Transgender Persons Act vis-a-vis NALSA judgment. So that was the topic of our previous seminar conducted yesterday only. And now we are discussing the right to self-identification and the right to privacy, one of the most sacrosanct and the most fundamental right. And as Dr. Smitra Singh ma'am has already told, and it is inseparable from the right to life. So right to life is inclusive of bundle of rights, and right to self-identification and right to identity is the basic right without which no human dignity is going to be ensured. Under the light of the international legal principles as well as under the constitutional jurisprudence, we are going to discuss this important theme today. And we have with us esteemed speakers from diverse areas and different universities. And even though we have with us Saksham Jain, who is working in this field from the past 3 to 4 years. And we have with us Dr. Mitali Shrivastava ma'am, we have with us Dr. Amit Dal sir and Dr. Santosh sir. So likewise, in the coming webinars, we are going to discuss some other aspects of this particular legislation, even though we are going to discuss the implementation dimension by way of discussing this particular theme under the title social and legal status of transgender persons after the passage of this particular act. And most importantly, we are also going to discuss this particular theme, whether this particular legislation is in consonance with the international human rights commitments. As in the previous webinars, through discussions with Justice Rajesh Tandon sir, and we have with us very eminent speakers in the previous webinars, Ghulam Yazdani Saab, and a number of speakers from the field of media and human rights activists also. So they have also discussed this thing that there are still certain rights which still have not been able to be incorporated, or that has not been translated into this particular legislation. So we are also discussing this thing, what additional we can do for improving the plight of this particular community. And most importantly, we are also going to discuss the welfare initiatives and schemes that are undertaken by the government of India for the protection of the rights of the transgender persons. And most importantly, I must say, the National Institute of Social Defense, who is the main collaboration, who is providing the main collaboration in this particular webinar series. They have initiated a number of measures, be it in the form of the national portal for the transgenders and number of other scholarship schemes for the transgender. We have rehabilitation homes nowadays. And even though most of the state governments are also doing a number of efforts by providing special grants, by we can say enrolling transgender people in the census roll. So time and again we can see there is a constant evolution of jurisprudence in terms of the rights that are going to be granted to the community, but still we are very far away in realizing the rights of the transgender people. And that's why we are conducting this webinar series. And I'm very thankful to all the firstly all the speakers who have taken their time, valuable time, and be with us, and they are going to share their valuable opinion. And most importantly, we are thankful to the chairman sir, our giant of choice, and Professor Dr. Aditya Tomar sir, especially reason being is the prime motivation behind this webinar series, and to Dr. Smitra Singh ma'am. So thank you, Sparna ma'am. Thank you so much. So please start with the proceedings, ma'am. Thank you.
Thank you so much, sir, for such exhaustive explanation, which is required in itself a great part where we are disseminating this information to make it accessible. Thank you so much, sir. Now I request to begin with the proceedings. For that, I'll begin with Saksham Jain, ma'am. Saksham
Hello,
Jani.
good afternoon, everybody. Am I perfectly audible?
Yeah, Saksham. Yeah, please.
So, since I'm also a student, third year student employed in EJS, and I am the founder of the Quest from Jammu. So, I will not only speak on, let's say, the only legal matters of it, but I would try to get into the topic via, let's say, the history of it, let's say, my personal experiences, and the whole sociology of it. So if we speak about the Transgender Protection of Rights Act 2019, this act came into force by the on 5th of August. It was introduced it was passed in the floor of Parliament, 5th of August 2019, and then subsequently later in Rajya Sabha. But how it started was the landmark Supreme Court case of 2014, NALSA versus Union of India, National Legal Service Authority versus Union of India. So how it started, so NALSA was, in many ways, a very big challenge to Suresh Kumar Kaushal and all the precedents of, let's say, trans jurisprudence in this country. 2011 was the first time when transgender people were introduced in the census of India for the very first time since its inception. So what was different in NALSA judgment, which subsequently enabled the parliament to pass a law like that? So NALSA judgment was a two-judge bench, so was Suresh Kumar Kaushal, but what was inherently different in NALSA was the jurisprudence of it. For the very first time in the history of India, independent India, transgender people were not only recognized with the apex court of India, but also entitled to all the protections under Part 3 of the Indian Constitution. Then it went on to describe the transgender identity as an umbrella identity, and also included the various ethnic identities like the Hijras, the Kotis, the Shiv Shaktis, the Sakhis, Manglamukhis, etc., etc., etc. So then the Act 2019 came into force. It is a welfare legislation, like all other legislations, has various provisions, mainly dealing with civil law, except one section which deals with criminal penalty, in which the maximum punishment is up to 2 years, starting from 6 months to up to 2 years. So when the act came, although it was for the welfare of the transgender community, we saw massive protests from the community, not going into the politics of it, because we'll stick to the law point of it. There were massive protests, so much so that the chairperson of UNHRC India had to write a letter that how bad inherently the law was. This was not the goal of the parliament, to actually bring in a law after so long, to actually instigate the community. But what essentially lacked is transgender people and the whole understanding of transgender people. Who are transgender people in the end? This fact was not even clear to the court in even in NALSA judgment. And we see the same traces of it in the law also, which came up. Two interesting things which NALSA said and was actually taken by the parliament was that right to identification was a right which was given in NALSA judgment, along with a couple of other things, including a horizontal reservation, which wasn't taken up by the parliament. Interestingly enough, the parliament also says the same thing in the law, that you can self-identify, but then goes on to lays the procedure for actually changing your identity legally. So that was one interesting thing which we saw. But coming to the question, why did all this happen? Because I have no reasonable intelligence here to believe that the parliament did it out of malice. The parliament actually wanted to give a remedy. The Supreme Court of India actually wanted to give a remedy. Why do you think it happened? It happened, as per my analysis, and a lot of other scholars like Vikramaditya Sahai, Rachna Mudrabaina, Akhil Kang, the court and the parliament was not clear that who is a transgender person. Because in the court's mind and in the parliament's mind, a lot of transgender, and in general masses of India, transgender community refers to the Hijra community. Hijra community is a part of the transgender community. all hijras are transgender. Not all transgender people are hijras. Although hijra community is a 4,000-year-old ethnic Indian trans community, and as India has also other various ethnic trans communities, but it is more than that. Transgender men exist, transgender people exist, and also ethnic transgender people also exist, Kotis. No remedy has been provided by the law. Even in the landmark case of Navteej Singh Johar, the law gave the remedy to, let's say, a cis Savarna gay man, which was anyway having the privilege to live. Because sexuality is something which can be behind closed doors. But what about people like Kotis, who are essentially transgender people? The law recognizes it, says that they are part of the transgender community. But the very idea of who a transgender is not very clear. Which brings me to a basic idea. I wanted to do a sort of social experiment, but since we do not have students, this goes down to the question of what is the difference between biological sex and gender identity. And mind you, transgender people are the third gender. They're not the third sex. So the law still does not recognize them as the third sex, and which is also not medically true. So what constitutes biological sex? If anybody would like to answer. Essentially, there are three components to biological sex. One is the chromosomes, second is the secondary sexual things like hormones. Third is your genitalia. For all practical purposes, all across the world, there's no country which actually considers all of these factors into account. Genitalia is the only factor based on which biological sexes constitute. Now it brings us to an interesting factor. Even if we say that genitalia is the only thing by which biological sexes constitute, the question arises that there are actually not two biological sexes. Intersex people have always existed, and intersex people do not conform to this biological category because medicine for the longest period of time and the medicine we study, including our laws, are colonial. And that mindset is carried forward. So what we essentially call as Klinefelter syndrome is a biological variation. It's not a disease. So not going into too much of biology, but the law, because it couldn't understand what a transgender person did, was to club intersex identity with transgender identity, which is essentially two different things. This is what happens when you cannot make a person real to the law, real to the legislature. And the same thing was asked by a judge, Justice Singhvi, in Suresh Kumar Kaushal, that to Mr. Mehta, who was the Solicitor General of India, that Mr. Mehta, have you ever seen a gay person? And Mr. Mehta could not reply. This is what happens when you are unable to make the person, because at the center of the law lies the person. The whole person is the center of which the law arises, and from the person, the law starts. And when who that person is not very clear to the law, to the legislature, these problems will arise. So why do you think the definition of a transgender person is not very clear? Considering I have spoken and all of you know that India had the world's oldest ethnic transgender community. Why do you think that happened? A community so old, so much respected, also so much respected. It was not a normal marginalized community. It was at the echelons of power. They were very close to the monarchs, which was a form of government at that point of time. And even if I speak of mythology, they were considered demigods in India. What's changed? What changed essentially was when British came to India. They could not digest that how are such paganistic, and they use these words, and that can be seen in the first I would still call it persecution, not prosecution. The prosecution is what we legally would define it as, but it was persecution of transgender community and queer people in India. First prosecution under 377 was none other than was of a trans woman. The case was Khairati versus Queen Empress from Allahabad High Court. If we read that case, we have a fair deal of understanding what the British meant for Section 377 to be introduced. They use the word that this person is a habitual sodomite, although due to other reasons they could not prove in the court of law, so they could not prosecute Kherati. But this is where the start of, let's say, colored bodies start. Section 377, which was prima facie a neutral section, it enabled the court to give an interpretation in which the certain bodies, by the virtue of their existence, were criminals in the eyes of the law. And then Criminal Tribes Act happened. The same legislations under which scheduled tribes of India were marginalized. There were two sections of people actually who were marginalized: scheduled tribes of India and the Hijra community. A lot of people tend to either neglect or not speak about it. Because if we are to speak that they had the same level of marginalization, then we should also understand that why are they not being given the same horizontal, the same enabling provisions? Why are they not being given reservations? So post Kherati and the Criminal Tribes Act, what essentially, and there were series of acts actually. There were series of acts. There were series of acts which were passed here, and the Bombay Rent Control Act being one. There were a lot of cases which were passed in colonial India here and there. One was Naushirwan, which was in, I guess, Bombay High Court. These cases actually identified certain people as colored in the eyes of law, which were inherently criminals. And for these people, they had to be actually treated by the law. So these people actually came into the purview of law like that. And there was subsequently a lot of challenges which happened to 377. The first one was being AIDS. It was the AIDS case in which in AIDS case in Delhi, in which the administration of the Har jail did not wanted to acknowledge the fact that condoms had to be distributed because the AIDS pandemic was going on. But inherently, essentially, what I want to say is that when we are not clear about who certain people are, because of the historic marginalization, I have no reason to believe that the Parliament of India and the Supreme Court had any other intentions but the welfare. But this is what happens when we are not able to make clear to the law who a transgender person is. This is what brings me to my second contention, is that we do require equality laws along with horizontal reservations, because horizontal reservations was something which the Nazi judgment spoke about, but now it has just vanished into thin air. Except the state of Karnataka, there is no other Indian state which provides for horizontal reservations. And we have seen by our experiences with the other marginalized communities, reservation does provide you the visibility. And when that visibility would occur, these things which were essentially born out of negligence would change. Because the parliament did not know, the best people in the country did not know, Supreme Court judges did not know who are transgender people. And they're everywhere. They're in your families, they're your colleagues, they exist everywhere. Now coming to the point of the main contention, privacy laws, vis-a-vis self-identification, vis-a-vis the rules and the act. So the rules, for a greater part, since I spoke that how there were large-scale protests, the rules were provided a remedy of sorts to these acts. The rules, so the act now has to be read along with the rules. So under section 7, which was for changing your which was changing your gender identity legally, earlier it was at the discretion of the district magistrate, but now on the basis of, you just have to apply to the office of the DM with the requisite conditions, which includes the letter from the chief medical officer and everything. It is incumbent upon the DM to actually give you the certificate of identity as a matter of right, which was something discretionary earlier. When we speak of privacy, we all tend to go towards the case of K.S. Puttaswamy versus Union of India, which was a landmark case on privacy. And it went on record to say that your sexuality and your gender identity is an integral part of your right to privacy. which makes the debate altogether very clear. The right to self-identification will only allow the law to be more trans-friendly, will only allow the people to avail these benefits. Because now I'll come to my personal experience. I've spoken about laws and everything, and a lot of you people know much better about laws than me. But what do I add to the table is my personal experience. So while working with the trans community in Jammu and Kashmir, and Jammu specifically, we work in Jammu mainly, we have realized only 1% of the whole transgender community have their identity as transgender on paper. What it essentially does is that deprive of transgender people of the rights given to them by the Parliament of India, by the law of land. They do not have the access to that because the very access lies on the fact that they have to have a certificate of identity as certifying them as transgender. Now, why does that happen? It's not that these people do not want to have a certificate. It essentially has happened because of compounded structural marginalization. You cannot expect a person who has been thrown away from their home, who hasn't studied possibly beyond 8th or 10th standard, whose primarily occupation is either a thing called toli bhadai or sex work, to walk up to the district magistrate and say that, hey, I need my identification, to walk up to the doctor and actually have the privilege to just go and undergo that whole counseling procedures. Self-identification was actually changing a lot of these things. Because the parliament wants the welfare, because the Supreme Court wants the welfare, but because of the fact that you really do not know who the transgender person is, you commit certain mistakes. And I would not say India is the only country who does not allow self-identification. A lot of countries do not, including the global north, which we think is the torchbearer of human rights. But what essentially is different in India is the very fabric of India, is the very culture of India, which has always been trans-friendly. So India needs to look up to other countries to make that change, needs to look up to other conventions to make the change. And when I say it, I'm well aware of the fact that being a student of law and justice and human rights, how much international precedents play a role. But all that I'm arguing is India has the inherent capacity to make that change. Because from global south, if this change happens, global north would have to think about how have we systematically marginalized group based on which we claim to the global south that you are not complying with human rights obligations. So I would just like to rest my case on that. And if there are any questions I'd like to entertain on them, I hope I was able to give a clear idea, not so much on the law, but the whole background and the sociology of the whole matter.
Saksham, I must say you were mind-blowing in your content. Am I audible?
Ma'am, I'm not able to hear you.
Yeah, am I audible?
Your voice is actually very less.
Is it okay now?
Yes, ma'am.
Okay. Yeah, I am acknowledging and appreciating the way you have addressed to us. Certainly, you have dealt with all the personal experiences and quoting the cases also, where you are saying you have not gone with the legal provisions. So far, I have gathered good information, and you have rightly quoted the judge's statement also in questioning how to address or have you ever met. Does this ever need recognition also? You have rightly pointed out the persecution of transgenders rather than the prosecution. Further to the quoting of the judgments from NALSA to the other, you have led the challenges also very clear by giving the examples of first aid also, where the other administration, prison administration, is also not accepting the reality, which is very harsh, and I accept that. Along with these challenges, you have come across with the reservation and the privacy laws also, and you have made it very clear to us that the law as an act must not be read in isolation. It is to be read with the rules. So I think you were too exhaustive in the content in this short span of time. Really thankful to you, Saksham. And I think there so far there is no question or any observation by our audience. But soon, if it will be, I'll be happy to put forward in front of you. Thank you, Saksham. I now invite Dr. Mitali Srivastava to please address us.
Thank you so much, ma'am. I've prepared a PPT. Is it okay if I share?
Yes, yes, please, ma'am. There will be
Okay.
an option at the bottom of the screen
Sure, ma'am.
with the share screen.
Would you let me know if it's visible?
Yeah, it is visible, ma'am.
Okay. Just
Yeah.
give me one moment.
All right. Audience is requested to please hold on their questions till the session gets over, concluded. As it is written in the chat box, please go with the compliance.
May I
Over to
start?
you.
Ms. Suparna?
Yes, ma'am. Over to you, ma'am. Thank you, ma'am.
Thank you so much, ma'am. I would like to congratulate Mr. Saksham for such an insightful discussion on the topic and taking us through all the colonial laws that also existed. Now, I would bring back the audience to the more contemporary situation. I focused my discussion mostly on the rules part, the legal framework, and what the rules particularly deal in, as the other aspects have been so beautifully dealt with by my co-panelists. I would start the discussion with the question as to who is a transgender person, because clearly, as my co-panelist also said, this is something that is not clear to many people, right? And transgender people are considered people whose gender identity is different from the gender that they thought they had at birth. So it is more to do with gender, as you said, and not sex per se. These people may be born with male or female anatomies, but they feel different from their body structure, as their gender expression, their identity, and particularly their behavior differs from their birth sex. Transgender people try to express their gender identity in many ways, as and some mostly use their behavior, dressing sense, or mannerisms to live like the gender they feel is right for them, as they reject the traditional understanding of male and female as the society has so mandated. This term is not limited to those whose genitals are intermixed, but it is sort of a blanket term of people whose gender expression, identity, or behavior differs from the conventional norms expected from their birth sex. The discussion will be mostly focused on rules that were given in 2020, and I take you through the history, a brief history, the overview of these rules, and a little bit of the challenges that are posed later on. Now, in September 2020, the Union Ministry notified Transgender Persons Protection of Rights Rules 2020. Now, the significant contribution of these rules was the mandatory medical examination requisite that was created in the previous draft rules was done away with. The earlier draft was heavily criticized on this basic point, that the medical examination and also the determination of the gender of this person was determined by a third party, which is the district magistrate in this case, to verify and certify someone's gender, which was thought about as a breach to a person's right to self-determination and autonomy. Now, in addition to being an infringement upon the constitutional right to bodily autonomy and their protected right to privacy, the previous draft was also vaguely and unequivocally, it reaffirmed or sort of the question on a person's right to self-determine his own identity and protect his privacy as well as dignity. Now, in the light of such criticisms, the new rules have made the change wherein the district magistrate now is just an authority that processes the application for a transgender person to declare their gender. So it's mostly a declaratory power that this person has. And this declaration is given based on an affidavit that is submitted by the person himself. And there is no physical or medical examination required. Now, the main component of these rules is around the certificate of identity that is issued. Now, under Section 22 of the Transgender Persons Protection of Rights Act 2019, the central government has the power to formulate rules, and the rules are thus formulated under that particular power of Section 22. The certificate of identity, first of all, has to be applied for by the transgender person himself, or in case of a minor, as well as in case of a child in need of care and protection under the Juvenile Justice Act. It can be done on behalf of the parent or the guardian as well. This is done under Form 1 that is given in the rules. The application has to be submitted along with an affidavit, which is a sort of a self-declaration by the person who wishes to declare their gender as such. The application is submitted to the district magistrate. It can be done either in person or by post. The Act provides for a possibility of online application as well. However, the state governments are required to frame rules around that particular provision, and it is not clear as to how it will happen. But as for now, it is in person on post, but with a possibility of an online application as well. The application has to be processed within 30 days. And the main idea behind this certificate of identity is that it acts as a conclusive proof or as a basis for the person to change his gender as well as his name, as well as his photograph in all other official documents that need to be certified. The power of district magistrate is also clearly given in these rules, wherein the main job of the district magistrate is to verify the correctness of the particulars of the affidavit as well as the application, then also determine the place of residence of that particular person, because that will determine the jurisdiction of the district magistrate, and as well as issuance of an identification number. There are three elements that are issued by the district magistrate under these rules. First is the identification number that is given to the applicant upon the submission of the application. Then you have a certificate of identity that we just talked about. Based on this certificate of identity, there is also a transgender identity card. The job of the district magistrate is to verify the details and the particulars. He or she, however, cannot conduct any physical examination or order such physical examination. However, under previous act, if any person has already received a medical certificate by the CMO as provided in the previous act, then that affidavit can be attached, and the district magistrate will also check the verifiability of that particular affidavit. Along with, because he has been given the power to verify and the power to issue the certificate, he also has the power to reject. However, these powers are very limited in nature, and the district magistrate has to record the reasons as to why such a rejection has taken place. So the reasons for these rejections are to be recorded and cannot be vague in any form. Apart from the role of the district magistrate, the role of appropriate government also comes into picture largely, wherein the appropriate government, first of all, has to maintain a register of all the identity cards issued under these rules, as well as the transgender identity cards. Now, apart from this, the appropriate government is also tasked with the responsibility to ensure maximum registration, which is why if there are people living in remote areas or are under any disadvantaged conditions, then it is the job of the appropriate government to facilitate the registrations of such persons. Apart from this, as I spoke before, online facilities are also to be provided by the appropriate government. Then the appropriate government is also required to put in place the appellate authority which will look into the applications in case any application for registration is rejected by the district magistrate. Now, apart from these, if any offense has been, if any offense has happened against any transgender person, then it is also the job of the appropriate government to ensure that the timely prosecution of such offenders also takes place. These are the main roles under these rules. Apart from these, this appropriate government is also tasked with certain policy making rules. Now, first thing that the appropriate government is required to do is to create a welfare board. The job of this welfare board is to come up with welfare policies, schemes, and measures to protect the rights and interests of transgender persons and to facilitate access to various things. Then appropriate government is also required to review all the existing educational, social security, health schemes, etc., along with welfare measures, training schemes, vocation, self-employment schemes, to facilitate access of these schemes to the transgender persons. Apart from this, apart from the formulation of educational, social security, and health schemes, adequate steps have to be taken by the appropriate government to prohibit discrimination as well, whether it is any government organization or a private organization, including educational institutions, which is again very significant here. Now, the government is also to provide equitable access to social and public spaces. Now, these include burial grounds as well to the transgender persons, and create institutional and infrastructural facilities such as washrooms, then your hospital wards, short stay homes, temporary shelters, etc., within the 2 years from when the rules have come into force. Apart from this, the appropriate government shall also organize awareness campaigns to educate, communicate, and train transgender persons so that they are able to reap the benefit of all these schemes and measures that are created by the appropriate government. Then institutions are also supposed to be sensitized by the appropriate government, wherein the rules talk about sensitization and training of not just teachers, but also changes and revisions in curriculum, then training of healthcare professionals, sensitization programs at workplace, and institutionalization of or setting up of complaint officers. Now, appropriate government is also required to formulate a comprehensive policy on how these measures and these schemes are going to be implemented under these particular rules. Another important thing that not the appropriate government but the state government has to do is to set up a transgender protection cell. Now, this cell in every district will be under the charge of the district magistrate, and on every state it will be under the charge of the DGP, so that whenever any offenses occur, there can be timely registration, investigation, and prosecution of these offenses as well. There are certain other compliances under these rules as well. So the first thing that these rules focus on is non-discrimination in education sector. So all educational institutions are supposed to have committees which address any cases of harassment or discrimination. And these committees also are tasked with making these facilities more accessible to transgender persons in those educational institutions. Then the rules also provide for equal opportunities in employment, wherein every establishment will also implement certain measures so that a safe working environment is created, so that no particular transgender person feels discriminated against, and certain infrastructural adjustments are made wherever deemed necessary for the promotion of this act and these rules. Now, an equal opportunity policy is also supposed to be published by every establishment, and this policy is to be displayed. It should contain the details of all complaint officers, etc., at all prominent places at the workplace, and also, if preferably, then on the website of that particular establishment. Infrastructural facilities obviously have to be catered to as well in these cases, wherein every employer is supposed to provide for infrastructural facilities, as well as maintain the confidentiality of the gender identity wherever required, and facilitate complaints to the complaint officer. Then grievance redressal mechanism is also set up under these rules, wherein the appropriate government has to establish or designate a complaint officer within 30 days when the rules came into force. And these officers, the complaint officers, within 15 days have to inquire into whatever complaints they receive. The head of the establishment, wherever that complaint has occurred, also has to prepare an action report, an inquiry report based on the report of the complaint officer and submit it within 15 days. Now, apart from this, the appropriate government is also tasked to set up a grievance redressal mechanism, which is sort of a helpline to facilitate the access to these complaint mechanisms, and as well as set up certain outreach centers wherever possible. Another thing is the National Council. The functions of National Council are clearly given under Section 17 of the Act of 2019. However, these rules just provide that the National Institute of Social Defense will provide secretarial assistance wherever necessary to the National Council as well. Now, these are the general compliances and general things about the rules or the legal framework around the rules. Certain things that, or certain areas where the rules have now opened the discussion is, first of all, the debate on medical tests as a parameter to determine gender. This was very important, and I'm thankful or grateful that this was done away with in the present rules. However, just an isolated reading of these rules does not authentically display or portray the actual range of issues that are involved in this struggle to establish this rights discourse. Also, as talked before, the NALSA judgment was very important in this case, where the transgender people were declared to be a third gender. The court also interpreted the word dignity under Article 21 to include diversity in self-expression, which allows a person to lead a dignified life. Now, it also placed one's gender within the framework of the dignity of Article 21. Also, it talked about the right to equality and freedom of expression, wherein it was framed under gender neutral terms, saying all persons. Article 15 also becomes very relevant here, which prohibits any discrimination on the basis of sex of an individual, which must include the transgender people as well. Now, certain challenges that may be faced here are the definition, wherein discrimination and the term transgender is vaguely defined, especially so discrimination. Now, that becomes a challenge when going through the grievance redressal mechanism. Another thing is that any sort of civil or criminal remedy is not adequately provided for, which becomes a challenge. Now, from a social welfare perspective, these rules advocate for welfare schemes, programs, protection cells, etc. However, they remain vague as to what exactly these welfare schemes or measures would be, and what would be the time duration within which the state would be required to implement them. So that becomes another challenge. However, in the NALSA judgment, the transgender community is described as socially and economically backward, and hence entitled to the benefit of affirmative action policies, whether in education or in employment. But the Act or the rules do not talk about its implementation. So that again becomes a challenge. That being said, let us hope to find more solutions to this problem rather than discussing the problems alone. Thank you. That is all from my side. If there are any questions, I'd like to take them.
Thank you, Dr. Mitali Srivastav. Indeed, it is a pleasure hearing you also along with Saksham Jain. You have put forward the correct question to us, that is the identity, which is required as a certificate. You left us with all the answers where you started with what, by who, and by whom, how, when, why it is required. And so you have dealt with the issues to make it more legitimate and authentic and genuine. The role of the district magistrate was discussed along with the appropriate government's role, which is required for the registration. Certainly, with your thoughts, you have made it accessible even for the remote areas, or you can call it as disadvantaged conditions. Your emphasis on the training programs, formulation of the policies, which are with reference to no discrimination in education, providing equal opportunities for the employment. The grievance redressal is also being, elaborately dealt, and so the role of the National Council. Indeed, ma'am, you have said it in a correct way that despite there are multiple provisions in the Constitution of India, right from Article 15, 19, 1A and 21. For others who are ignorant about these constitutional rights, certainly with your insights today and your Saksham Jain's introduction, things will be more vital, clear for others, where they can think and they can initiate the proceedings for going with the identification for the today's topic, which is correctly going into the correct pitch. Thank you. Thank you so much. I request Dr. Santosh Kumar to begin with the views. I request, sir, please. Sir, I hope I'm audible.
Yeah, you are audible. Am I audible?
Yes, sir. Please, over to you, sir.
So thank you very much for the deliberations for every side. And I would like to put forth Saksham Jain's view in the practicality. And my congratulations to Saksham at the very first stage that he is working practically. And Dr. Mitali's deliberation is also very good with regard to the theoretical perspectives and the rules for. But here, the right to privacy and the identification problem is a very relative criteria. I want that the deliberation should be transacted like that we can take this particular issue in right direction by certain practical acknowledgements. May I ask a question that can we claim that, oh, that particular transgender is my friend? I think impossibility. Saksham Jain may give the clarification later on as he is in the field. So the field acknowledgements are very much pertinent to the effect, because everyone, when we are going to take the law in its right direction, we will take to the cause to the effect, basically. So if we are going to look into that particular aspects, as the law has always, that law having the gap at the theoretical perceptions and the practical perceptions. So I would like to give a particular phenomenal advancement that we should work for the not the gender justice, gender equality, but the gender equity too. But that will start from individual itself. And if we are going to accept, as Dr. Mitali has contended for the social acceptability. So I have reminded for the very recent film, The Lakshmi itself. I will talk very practically. That particular social behavior and the pattern, I am using the word pattern regarding that particular behavior, though that is sometimes not very much appreciable, but with regard to our social acceptance, that is very pertinent effect, that whether we are going to accept this community with regard to our private affairs also, family affairs also, that is the million-dollar question. A very instance I would like to put here, where I am residing, there are certain persons from this community residing. And once it happened that particularly those persons, if you are moving here and there, the gentlemen and the particular ladies of that particular mohalla itself, that means colony, not going to talk upon, not going to see, not going to watch out the certain things, just they are having the enjoyments that they are residing here. So what I want to say here, that if they are having certain privacies, then that has the equal equation for them. They may protect themselves, but naturally as a societal approval, we have to protect them. We have to assimilate them. Not only the rules are doing, but our social pattern is going to do something. So that's why if we are touching upon only the provisions of the law, then naturally the law must be there, but our social pattern, our political pattern, our economic affairs are contributing towards the betterment of the society. And if the transgenders are treated like our genuine part of the society, then I think that can be certainly will be the purpose of this particular webinars and the Ministry of Social Justice itself and the National Institute of Social Defense. And I think everybody is inclined towards that particular betterment of the transgenders. But historically, if we are talking, so from the inception of the Constitution as the welfare state itself, if we are talking about that particular right to privacy, it starts from a very earlier decision, we can say the Khadak Singh's case. I think as a student, we have all gone through with this particular 60s, 1962's decision in Khadak Singh's case. They have recommended that the right to privacy in limited manner as a surveillance is concerned. But later on, with respect to the Nalsa case and later on the Naj Foundation case, and most recently, the Putta Swami's case has given the lot of weight to these particular discourses in diversified manner. Now, if we are going to take an attempt for that particular betterment in dignified manner, because that has also the repercussions. What is the dignity with a particular person? It is also a very drastic question to be answered, because the dignity has various parameters, various particular denominations. But the Putta Swami case has also highlighted that particular version of the privacy itself, and every individual, including these particular transgenders, may argue for, and they will be protected with that particular concerns of right to privacy. So, with regard to that particular case laws, with regard to the particular legislations, not only they are going to do that particular cause of justice, but in a composite style of functioning as an individual, we all have the duties towards these particular persons, not only with regard to that particular social concerns, but also to the professional concerns, their particular status in the society, and the well acceptance of these persons without any discrimination so far. One very particular presentation prepared by the Mitali ji, I would like to take the advantage of that particular principle she has highlighted in human rights version. In her slide, she has given a particular view of the Yogya Karta principles. That is the highlight version of that particular earlier decision from which this particular law has arrived here. So that Yogya Karta principle has also got the status of the international human rights version. The English version may be read out as follows: principles on the application of international human rights law in relation to sexual orientation and gender identity. So that was the crucial judgment, and that is the opinion of Justice Radha Swami at that point of time when he was delivering that particular judgment. So if you are reading that particular judgment, you will get this. And not only that particular Yoga Karta principle has highlighted that particular gender identity as an status granted to a particular individual, irrespective of that particular medical and biological differences. If you have been assigned a particular gender, then go with that. Though in real practices, we have got the change of the gender. Now the medical advancement are very good and but not very welcome, and they are giving our that particular connotation for the twisting of the society as well. Recently, I think you all have heard that there is an option and they are opting for the change of gender sometime from male to female, female to male. But whether these transgender persons are also going to be highlighted for this particular class, this is the also concern for that particular our legislative practices. So not only the legislative practices, rules, but the latest practices of the whole of the social behavior pattern, I think that will be the responsible factor for the all type of betterment of this particular class of persons. So not making too much that particular elaborations, because the webinar will go on. And earlier was also I was part of that particular webinar. So a lot of deliberations on human rights and the issues there. But let me congratulate to the organizers for touching upon that particular aspects with regard to the all the concern areas for the particular purpose of this particular webinar and support system they are getting from the Ministry of Social Justice and the National Institute of Social Defense. So thank you very much. And if any question is there, we will deliberate and we will answer, and we are happy to answer. Thank you very much. Thank you so much.
Sir, if you allow me, I have a small question.
Yes, please go ahead.
Sir, you had referred to, in reference to the right to privacy, when you are actually reading down the patterns, actually you had referred to the right to privacy within the meaning of Article 21, and you had also referred to the Karak Singh judgment and later on the Puttaswamy judgment. However, from Karak Singh to Puttaswamy, the court actually has had deviated. So Karak Singh was largely on bodily privacy, and we moved away quite far from that part of privacy to data privacy. So how do you in light of the Puttaswamy judgment, especially with reference to data privacy, Aadhaar Act was in contention. So how the transgenders rules vis-a-vis the rights that bestow on them, so how they may be related? Just an observation or a question, sir, if you could.
Yeah, very rightly so. We would like to go for the census in 2011. Approximately 5 lakhs persons are available as per the previous year our census data. But now I think that has been increased so far with respect to the latest data. So whenever you are framing a particular statutory provision, we have to look for that particular number of persons. And if that formulation is available, as you have rightly pointed out, that how we are going to take that particular data means for that particular betterment of that particular transgender persons. So we have to take note that what is the latest position as the number of persons available with regard to the transgender issues. So as data protection bill is there, and we are hoping that that law is coming to that particular arena of the legal framework very soon. But if law is not available at this time, so we have to take that particular advancement as the zigzag journey of the court's decision. But if we have got a particular legislation to work for, then we have to rely upon. So what is the present context? That we have got the law in the form of that particular protection of the rights of transgenders and rules so far. But we hope that particular data protection law have also certain provision to get that particular effect done. with regard to that particular data protection means and betterment of the transgender persons. Thank you.
Thank you so much, Dr. Santosh Kumar. Really, your deliberations has led to us a new thinking over here, where you acknowledge the efforts of others also in a rightful direction. You began your deliberation with that can we make a claim that someone is my friend who is also a transgender is indeed a question as an eye opener for all of us. So whether it is just the gender working over there as equality or to talk about gender equity, this is something which we have to ask ourselves rather than figuring out the answers or working in this direction of providing such vague term or a neutral term as equality. So let us talk about equity. Your present example, which has already illustrated by a movie Lakshmi, is also the way you address it to the behavioral pattern, which is acceptable also for others who are still not able to go with the principles. The Yokarta principle, which you have elaborately dealt with the English translation about the principles of application of human rights law, is something which we need to figure upon. Thank you so much, sir, for such an insight with the practical example, with the real and the real, where we have to go with the nexus. So let us not just go in the movie world or in the real world. Let us talk about something in reality, and that ground reality is being touched today deeply.
Thank you.
Thank you, Santosh, sir. So over to you, Rajat, sir, who is also a co-moderator with me. I request Rajat, sir, to take the session ahead. Rajat, sir, please.
Yeah, thank you and good afternoon, one and all present here. Thank you, our head of the institution and additional director, Professor Dr. Aditya Tumar, Professor Dr. Santosh Kumar, Dr. Amit Jal sir, Professor Mitali Srivastav, and other dignitaries, Dr. Nitan Sharma, and other dignitaries here. It was, of course, very nice to hear both Professor Srivastav and Professor Kumar on the rules and actually some of the intricacies, some of the intricate aspects which are related to the rules, the 2020 rules. So without further ado, I would request Dr. Amit Dhal, sir, who is currently serving as an assistant professor in the school, in the Amity Law School, Noida, to speak a few words on the transgender rules and the way forward. Thank you so much, sir, and over to you. Thank you.
Thank you, Rajatji. I, on behalf of the organizing committee, welcome both the speakers, Ms. Mitali and Mr. Saksham, who have elaborately dealt with the issues relating to the transgender community. Now, first we need to analyze what the problem, the crux of problem is. Where has the problem evolved from? Is that social awareness, or you can say illiteracy, which is lacking? Or we can say that the law is not being properly implemented. Although the rules have been framed in 2020, legislation has been enacted, yet we find there are a lot of gaps in administration of justice. Recognition of transgender as a third gender is not a social or medical issue, in fact, but it is a human rights issue, which has been pointed out by Justice K.S. Radhakrishnan also in the leading case. Now, what is the problem basically faced by the third gender? Why are we just recognizing them again as a third gender, not as a normal part of the population? Why do we need a special legislation to safeguard their interests? That is the problem which is being faced by the society still now. Now, there is some prohibition which has been put up by the new bill. Prohibition against the discrimination. Prohibition in case of jobs, in case of education sector, in case of healthcare amenities. The access to the services by the third gender community the transgender community. Now, the rights which have been evolved should be recognized as their basic rights. Now, they again need a certificate from the district magistrate to prove their identity. The Act calls for a national council for transgender persons also. Now, they have been provided some rights to safeguard their interests. The Act provides them the right of residence and provides that no transgender person, no member of such community shall be separated from their parents or from their family just because they are from a third gender community. The legislation also seeks to answer to their health issues, provide them the health facilities, surveillance centers, sex reassignment, surgeries have been allowed under the legislation. Comprehensive medical insurance schemes have been introduced under the legislation. However, even though there have been penal laws, penal provisions under the legislation itself, which criminalizes begging and forced labor and denial the access to public place, denial of the right of residence in household or village, that is living with the general community. Any abuse, whether physical, sexual, verbal, or emotional, has been made punishable under the legislation. Still, we find that the community faces certain challenges. The lack suffers from some shortcomings. The act, the legislation, the law cannot be properly administered until and unless the transgender persons are properly defined. There should be a provision for self-determination. There is no provision for reservation to the transgender persons as a whole, which to a large extent is not fulfillment of the verdict given in NALSA judgment in 2014, which sought to give reservation to the economic and educational backward classes. Now we find that the transgender community earn their livelihood by dancing and singing, and begging is their way of life. However, the act itself has criminalized the begging by making it an offense. And it has not even provided for any alternative action for some social scheme, some social security. You are taking away their means of livelihood, but you are not providing them with some alternative remedy. Now, even if you discriminate against the transgender person, trans people, the penal provisions for sexual assault are not as stringent as against cisgender people, where the imprisonment may be up to 7 years for sexual assault on women. We can analyze that the transgenders are not empowered with the rights under the legislation. They are still the victims. The rights which are normally available to the citizens, like right of having a social life, right to be engaged in marriage, the right to seek divorce, right of adoption, have not been taken care of under the new legislation itself. Further, the government may have been asked to take some initiatives to safeguard the rights of transgender community. Discrimination has been prohibited. Provisions have been made for national portal for transgender persons, where they can digitally apply for certificate and identity card. To avoid any physical interaction with the officials, the DM may be also put forward an application in this regard, as has been discussed by our earlier speakers. The appropriate government has been assigned the role to set up welfare board for the transgender persons to take care of their rights and interests, and has been also further assigned the role to review the existing mechanism, the infrastructure, the educational and social security schemes, the health sector, the vocational training, as well as the self-employment schemes have to be evolved by the government, appropriate government, for safeguarding the rights of this deprived section of the society. Some proper institutional as well as infrastructural facilities need to be introduced, whether they are temporary shelters, accommodation, hospitals, washrooms, but the government has to take the appropriate steps. It is a need of the hour to ensure the privacy and dignity of the third gender in place.
पेरेंट्स नहीं थे
शैलजा मैम को कुछ मैं बाहर बैठी थी थोड़ी देर
कहाँ मेरे
हाँ मतलब मैं
यहाँ तो नहीं आए कोई उससे रिलेटेड
अच्छा नहीं मुझे
कोई नहीं अभी तो ये आई क्यों इसी की
We find then over the years we have been adopting the old legislations. Even the Indian Prison Act does not recognize the sexual minorities based on sexual orientation and gender identity. It has only the provisions for separation of prisoners in category of women, young old offenders, or under trials, convicts in civil prisons or detainees or high security prisons. No separation of transgender community members. Now there should be some inclusive policies. Legal and law enforcement system need to be empowered with the issues with the proper schemes to deal with the issues relating to the transgender community. We need to involve the general public. There should be some public participation, social awareness to uplift this downtrodden section of this community. We need to address the social concerns of this community. Free legal aid, education to the deprived section, social entitlement need to be provided to the members of transgender community. There should be some financial security which needs to be assured. They should be given an opportunity to start up their own career as a businessman. We find that there is lack of legal protection. There is lack of social equality. The transgender community is ridiculed from the society. We find there are anti-transgender violence instances. So these all are the cases of social stigma they are facing. Non-discrimination should be the policy, and welfare schemes should be a measure to take preventive action to uplift this deprived section of the community. Discrimination cannot be prohibited by enforcing laws. People need to be entitled. Appointment of compliance officers according to the legislation may not help. We need to make people aware about the problems this community is facing. The legislation has missed to subserve the interest of the community to a large extent. The penalties for the offenses for transgender persons is only up to 2 years of imprisonment with fine, which is very much inadequate and not in parity with the general community. The rights have not been properly safeguarded under the legislation. The right to privacy, which is available to every individual, has not been properly safeguarded in case of transgender community also. And the legislation again has failed to provide appropriate remedy to safeguard the social concerns, the stigma which is being faced by this transgender community. But you are giving them an opportunity to get a certificate of your own sex choice, your own identity. You can get a certificate of identity for change of gender also to be issued by the district magistrate. But that will not provide them with the social rights. That will not provide them with the equality with which the other members of the community enjoy the special privileges. The basic rights, basic human rights should be equally available to these masses also. So it's a major concern that equality should be stressed upon, not as a legal concern, but as a social concern. Only by statutory declaration of certain rights, we cannot safeguard the interest of the community. They should be fairly adopted by the social masses. So, lot has been discussed, lot has been analyzed, but the genesis is that just by passing the bills or by making the laws, you cannot change the stigma which is being faced by this community. We need to educate the people. We need to make them aware about the plight which this community, these people are facing. And with that, I would like to thank the organizers, my respected HOIs, who have given the opportunity to deliberate on this important topic today. Any questions I would like to answer, please.
Any of the participants or the panelists would like to have pose any questions or have any observations for Dr. Amit Chand?
Sir, we have questions. I think Saksham has already answered. So nice of you, Saksham, who has written also to this extensive part. We have questions received also. If you wish to address again, Saksham, to the question which is being raised by the RFA.
Yes, ma'am, I just realized
I'll repeat the question for the audience.
Yes, ma'am. So the question, ma'am, should I repeat or?
Yeah, I'll say so. NALSA versus Union of India, the case is being cited, where it goes for the recognition of the rights of the third gender, whom we called as Hijra in our community. This is a question which is being put up. So going with this, the question is with reference to, is third gender prominent in other species as well?
Might I
Saksham,
answer it?
please.
Yes. So thanks, Arif, for that question. And thanks, Naheed, for that another question. To answer Arif's question, that is third gender prominent in other species as well? When we essentially speak of species, biological factors do play a larger part, not legal factors. We'll have to understand the third gender as a category is a sui generis legal construction by the Indian Supreme Court in Nalsa versus Union of India. It is not something which we can directly compare to, let's say, a biological category, because what does the third gender includes? Third gender includes transgender people and intersex people, because that is the legal definition. But the essence of your question, which I thought was, you'll be surprised to know that 65,000 of animal kingdom species out of the 7.4 billion, if I'm not wrong, are hermaphrodite, which essentially means 5% of animal kingdom is truly hermaphrodite, and that is not including insects right now. And then a lot of plant species are hermaphrodite. So what is hermaphrodite? Hermaphrodite essentially is a biological thing in which the, let's say, the parts of males and females as in plants or in animals are both found in one organism. One good example of it is the earthworm. Earthworm can self-reproduce also. And then you have, let's say, all the major flowers, like hibiscus as a flower is hermaphrodite. So that was the essence of your question. Now, regarding the other question that NALSA versus Union of India recognize the third gender, who we colloquially refer to as the Hijra community. So that Hijra community refers, again, Hijra is one of the word which the ethnic transgender identity community has. Then there are Kinnars, which is an older identity, because Hijra is an Arabic word which refers to people who go out of their tribe to seek the ultimate truth. It comes from the word Hijr. But Kinnar is an older community which were demigods. Then there are Nupi Manbis in Northeast. I study in Calcutta, so Nupi Manbi in the Northeast. Then you have Mangalamukhis, you have Shiv Shaktis, you have Jogappas. We recently saw Manjama Jogappa got the award by the president. Jogappa is an ethnic community from Karnataka. Then you have Shiva Shaktis, you have Sakhis. Sakhis are people who worship Krishna, and they are transgender people. Then there are Kotis. So, and then obviously, how can we forget, like the Khwaja Sira community. Khwaja Sira community is a very important ethnic trans community when we speak of Southeast Asia. They're also in India, but predominantly in Pakistan and Bangladesh. So Khwaja Sira community. And all these community, Khwaja Sira community, Kinnar community, Hijra community, have very strong religious roots to them. And in the Bible, and also in the Bible, we speak of the eunuchs. So all these three communities have, and specifically in Islam and in Hindu theology, these two communities have a very prominent role to play. So there are multiple names which they have. And one interesting fact, since we've spoken about it, you'd be surprised to know when Britishers came to Indian Criminal Tribes Act was passed, the Hijra community, which was at the echelon of the power and everything, they had to go underground. So they made a secret code word language, which we know as Kinnar Farsi or Hijra Farsi. So it is a code language. So they also have their code language. And a lot of their history is oral history. So it is they have a Guru Chela Parampara in which the Guru transmits the oral history to the Chelas. So that's how they function. But thank you for the questions.
Indeed, it was.
Thank you, Saksham Jain, for answering those questions. And thank you so much, Dr. Amit Dhal sir, for actually reflecting on those parts, actually, which the Act has not covered. So you have tried to explicitly focus on those areas which have not prima facie been covered by the Act and the rules thereof. And the possible way forward, you have referred to the self-definition part, which is a very, very important. So rather than seeking for an identity card from the government through the rules, invoking the rules and the provisions of the act thereof. Is there any provision? And you have also referred to the social construct and the stigma they face, and rightly so, that just merely providing welfare measures through an act or through statutory instruments may not be an overwhelming panacea. But having said that, when parliamentarians make acts or may there is something that goes in their mind, and of course it transpired largely because of the Nalsa judgment that we all know. But it remains, so it is a very new act in the sense it is only about 3 to 4 years old, and at this point in time, identifying the lacunae in the act or the rules thereof may not be justified, in the sense that we require some broader ambit of we require some more time to understand whether the actual rules or the provisions that have been made, the council, the mention of the council, or the equality provision. Even I have similar observations with reference to some of the rules. For example, Rule 12, which Dr. Mitali Srivastav had also pointed out. So Rule 12 speaks about equality in provisions of employment. However, the reference of that rule is to a policy. It is not law. It is not a law per se. So it is only an enabling provision, and it is not a direct what do I say, translation of the constitutional mandates that we have under Article 16, especially opportunities, equality of opportunity in public employment. And I do not know whether Article 16, we have the reasonable classification within the meaning of Article 14 read with Article 16. So if we read down Article 16, 4A and 4B, whether there is a further need to allow such a further classification, that remains to be seen. But however, having said everything what Dr. Amit Jhal had pointed out, some of the conspicuous lacunae in the provisions of the act as well as in the rules thereof, of course any act would not be able to address so many issues at one go, and this act has also failed to address some of the issues, some of the important pertinent issues. But it remains to be seen on a larger scale, the welfare measures contemplated under the rules, or the council contemplated under how the council functions. And especially, in almost every part of the rule, there is a conspicuous mention of appropriate government. Despite, as we all know, that directive principles of state policy, despite such directives, the constitutional directives actually, on many occasions, for example, the Maintenance of and Welfare of Parents and Senior Citizens Act, the rules thereof, they contemplate, they conspicuously say that certain old age homes and certain medical facilities, certain facilities are to be provided by the appropriate government. However, it was passed in 2007, and it is 15 years down the line. Unfortunate part is that many of such directives have not been translated into reality. Having said that, I would, before I formally close the session, may I ask Professor Dr. Aditya Tomar to have a few words, and then I can formally close the session. Thank you so much.
Thank you, Dr. Rajat Banerjee. Basically, in the end, I just want to pay my regards and sincere thanks to all the speakers. Without their valuable inputs, the session was not be able to complete it. So most valuable experience, practical, as also acknowledged by our senior colleague, Dr. Santosh Kumar Sakshamji, who just shared their practical experiences, and some of the words used in the answer of our question, Saksham. I heard even first time that you have a wide knowledge about the different communities which is popularly named with the different names. So thank you for sparing your valuable time and enlighten all of us. Secondly, the academic perspective. Dr. Mitali Srivastav, thank you very much that you just present a very wonderful presentation. And with the valuable inputs from our learned colleagues, Dr. Santosh Kumarji and Dr. Amit Dhar, just make the session live. So on behalf of all the members of Legal Aid and Literacy Committee, I just want to thanks to all the speakers and thank you very much.
Thank you, Thomas sir. I extend my gratitude to the organizers also for this webinar series, which is itself a great dissemination of the knowledge which is required for the transgender, which is dealing with the act also and the rules which is dealt today's topic with reference to self-identification. The privacy issues also were being dealt along with the practical examples, going with the real life to the real life. Really, it was insightful one. Thank you, everyone. Gratitude to all and to the organizers, Nitin sir, Sumitra ma'am, thank you so much, and Aditya Tomar sir. Thank you, sir. With this, Nitin sir, I request you. All right, with the permission of you, Tomar sir, I take this opportunity to close the session, sir.
Okay, thank you.
Thank you. Thank you,
Thank you, everyone. Thank you.